Jennifer Briel from Dinsmore and Shoals is here. She's been here before, but she's going to talk about what you need to know about the new recreational marijuana law. For over 17 years, Jennifer has dedicated her career to advocating on behalf of employers in matters of workers' compensation and employment-related issues. She focuses on representing and advising a diverse array of national clients spanning industries such as industrial leasing, skilled temporary companies, heavy equipment operations, restaurants, construction, foundries, healthcare facilities, manufacturing, and factories. So she offers valuable insights into employment and workers' compensation concerns. Jennifer has been a speaker at various Ohio Chamber of Commerce gatherings and Bureau Workers' Compensation Safety seminars. Additionally, she delivers seminars tailored for employers, industry trade groups, third-party administrators throughout the state. Since 2015, Jennifer has been distinguished presenter at our Ohio Safety Congress. Are you presenting this year?
No.
Oh, okay. And enlightening participants on critical topics like drug testing and other pertinent workers' compensation matters. She has been recognized as an Ohio super lawyer and by the Dayton Business Journal as a top 40 under 40. So without further ado, I want to introduce Jennifer. Thanks.
Thank you for having me again. I love to talk about drugs. It's one of my favorite things to do. And the reason we started talking about drugs, my former law partner and I, all we did was workers' comp. And there was a lot of misunderstanding with the employers we represented regarding drug testing. And when you have an employee who's injured on the job and they test positive for whatever it might be, whether it was drugs or alcohol, we had a lot of employers who thought, oh, we win. And that's not the case. So we really started doing these presentations to educate employers because your best defense is a good offense. I represent solely employers, so you will notice that my presentation is directed at employers. So a few statistics to get us started. Some of them might be surprising to you. In an average U.S. company, 15 to 17% of employees misuse substances. We're not talking about addiction, we're just talking about misuse. 38 to 50% of all workers' compensation claims are related to the use of alcohol or drugs. Drug-using employees are 5 times more likely to file a workers' compensation claim. And substance abusers use 3 times more health benefits and incur 300% higher medical costs. So something to keep in mind when you're considering what your policy is going to be. On average, employees with inappropriate substance abuse cost their employers $7,000 annually. So if you look at that, how many at the top, that 15 to 17%, and then $7,000 per person, that adds up relatively quickly. Okay, so I'm going to talk about the laws, but I'm going to talk a little bit about workers' comp in general first, because I feel like when we're talking about this law, especially in this group, we need to talk about how it interplays with the ADA, the disability laws, as well as workers' comp. So just a little bit of background on workers' comp. So the first question we always have is an injury compensable? Just because someone is injured while they are at work doesn't necessarily mean an injury is compensable. An injury includes any injury, whether it's caused by external accidental means or accidental in character and a result received in the course of and arising out of the injured employee's employment. So it's compensable if they are doing a required job duty, so something that they're required, or performing a job activity that is consistent with the employee's job and logically related or incidental to the employer's business. So just because they're on a break doesn't necessarily mean that if they fall in your break room, that's not going to be covered, right? So there are courts that have held that employees taking a break, that's still beneficial to you to have employees take a break, get a drink, get something to eat, and so they found that that can be incidental to your business. As long as there is some causal connection with the employment, and they look at the totality of the circumstances. Totality of the circumstances is legal jargon, but it's, hey, let's look at all the facts and see, is what this person was doing related to their employment? And the reason we want to talk about that is because there's actually a code section that talks about alcohol and drugs and intoxication and how it relates to workers' comp. An injury is not compensable if the injury is proximately caused by the employee's intoxication or drug use. And I'm going to talk about that in a minute because proximate cause is also legal jargon. What you think is proximately caused and what I think is proximately caused are different things. A positive post-injury drug test doesn't automatically mean that a claim will be denied. Far, far from it, okay? Employers should be aware that the Industrial Commission has strict requirements that have to be met before a claim can be denied based on intoxication or positive drug or alcohol test. So the first thing you want to do is prepare your defense before you even have an injury, okay? You've got to have a notice to your employees regarding positive drug use in the workplace. I believe, do they still send out the placards that you need to have posted? It can be in a break room. That's usually the best place to put it, is in a break room, or if you have somewhere that people can, if you have lockers, whatever that room is that employees use, that's where you want to post it. So you can say, they may not look at it, but you've posted it, so it is there, all right? You've got to post written notice that employees' eligibility for workers' comp benefits may be affected if there's a positive, two things, if there's a positive post-accident drug or alcohol test, or if they refuse to submit to a post-accident drug test. We're essentially saying, hey, if you refuse our drug test, we're going to take that as you were intoxicated or you were using drugs or alcohol. This is where people get in trouble. I can't tell you how many policies I've looked at that people are like, well, I've got a drug-free workplace policy, but it doesn't have the magic language. The language that we've highlighted here, if an employee is injured on the job, he or she may be required to complete a post-accident drug and or alcohol test. If it's positive, or if you refuse to submit to the post-accident drug or alcohol test, this may, not will, may affect the employee's eligibility for workers' compensation benefits. If you don't have this language in your policy and you want me to go to a hearing and fight a claim based on intoxication, I'm losing right out of the gate, okay? I'm going to lose. I'm just going to throw it out there. So everybody go back, especially if you can get reimbursement to have legal counsel look at your policy, go back and look at your policy. You want to make sure that your policy doesn't contradict itself. I have had so many people bring me their employment handbook, and what they'll do is they'll go to seminars like these and they'll take a handout and they'll shove it in their policy and make it part of their policy, but they don't take out what they already had on that issue. So make sure that when you're looking at it, you really do need to have somebody, whether it's once a year, once every few years, you really need to have somebody go through it. And you don't want a policy that's 100 pages long. That's not helping anybody because nobody's reading that. So you want to make sure that it's concise, but it's also got everything you need in it. Now, a positive drug test. This is our second roadblock. People will bring me positive drug tests that were done 4 or 5 days after the accident, and they'll say, look, positive drug test. I can't use that for an intoxication defense. So a test is positive. It was done within 8 hours of the injury for alcohol. That makes sense, right? We know how the body metabolizes alcohol. 8 hours for alcohol, 32 hours of the injury for drugs. Now, here's another place that we get hung up a lot. People will give me a positive drug test, and you know what it says? Marijuana positive. I can't use that either. Looks great, but I can't use it. I need to have the levels because the statute, the intoxication statute, requires a minimum level for the intoxication defense. So for marijuana, it's 300 nanograms per milliliter. So if you have your employees going to a facility, let's say they're going to Concentra, and they just give you back a positive for whatever it is, cocaine, marijuana, you need to ask them for the levels. The other thing you need to be aware of is sometimes if the person can show that they have a prescription for something, it won't show up on the drug screen because they'll negate it. They'll just take it off because they have a prescription. So be aware of that as well. I always tell people in their policies that if they're using a prescription that could impair their ability to perform their job safely or could put others in danger, that they need to make the employer aware of that. here's the next part about these drug tests. You can see it's not as easy as go take a drug test, it's positive, you lose. It's got to be given at the request of a police officer, given at the request of a licensed physician not employed by the employer. So I have seen this one where if they go to the emergency room, the doctor will do a drug test. They'll say, let's test this person, they're acting a little funny. Or administered because the employer had reasonable suspicion that the employee may be intoxicated. This one we're going to talk about a little bit more, and I love the fact that you can now get training for your supervisors and employees on what to look for reasonable suspicion. Because by the time I get the claim, we're usually a few months down the road, and if you have not documented things, it's very difficult for me to go back and get documentation. So when you have employees who are trained to look for things and you have an incident report, your employees can fill it out. You might even have a spot on your accident report, concern for intoxication or concern for alcohol or drug use. What creates reasonable suspicion? So things that you can see, what are you seeing about them? Direct observation of drug or alcohol use. That sounds silly, right? But I can't tell you how many times I've had somebody say, oh, well, their coworker said that they, on their lunch break, went out to the car and smoked a joint. Okay, well, we've got someone now. I need a statement from that person, but now we've got something that we can see. Possession or distribution. Anybody ever had someone distributing in your parking lot? I have. Physical symptoms, slurred speech, dilated pupils, odor of alcohol or marijuana. This one I have had come up as well. I had someone who, multiple employees reported to their supervisor that this person was continuously falling asleep on the job, they were slumped over, and then of course the person gets injured. So in that case, we had a bunch of statements from people, and it was in the file where they had reported this person was slumped over or they were doing something strange. A pattern of abnormal conduct or repeat flagrant violation of company safety rules. These two, kind of the only times I can use their own fault in a workers' comp claim. Because as you know, in Ohio, workers' comp is no fault. So it doesn't matter if they were breaking a safety rule at the time they were injured. It doesn't matter if they were doing something stupid at the time they were injured. If they are injured on the job in the course and scope of their employment, it can be compensable. But what I can use is if they have a pattern of abnormal conduct to say, hey, this person was intoxicated, they removed safety guards, they continuously stuck their hand in a machine, they were doing something silly, but that can also be reasonable suspicion. Accident reports, hopefully everybody does them. They do not have to be pages and pages long. I'm okay with a one-page accident report, but this is why they're so important, because you may not know what we need down the road. I want a statement from every witness who was there. I want a statement from the supervisor who it was reported to or who saw it. I want statements from everybody, because what you think I need to know and what I actually need to know may be very different, or there may be something very specific. Employees do come and go. So down the road, I may not have that person's, I may not be able to get in contact with them if they're no longer in your employ. They may not want to show up for a hearing. It's not as easy as you would think to subpoena someone for a workers' comp hearing. So getting those employees to get you a statement right away is very important when it comes to reasonable suspicion. So if you can meet those requirements for a positive drug test, and it has to be the qualifying drug test, the Industrial Commission will likely, I use the term loosely, likely find the employee's intoxication or being under the influence of drugs was the proximate cause, and the injury will not be compensable under the workers' compensation system. Now I say likely because if anyone's ever been to a hearing, you know that it's the wild, wild west. You go to a hearing, you never know what's going to come out of that person's mouth. I had one once where we had a positive drug test. We get to the hearing, and all of a sudden I start hearing things like, I was a drug addict, I went to prison, I came out of prison, I got this job and was injured 5 days later, but I also go to a methadone clinic. So guess what he tested positive for? In very high quantities. People say all sorts of things at hearings, so you never know what they're going to say. You never know Are you going to get a hearing officer who is employer friendly? Are you going to get one who is claimant friendly? You just never know. So the only other way the Industrial Commission can deny the claim is if there's a medical report from a reviewing doctor that reviews the intoxication levels and determines that the employee's intoxication was a proximate cause of the injury. So we do this a good bit. All I have to do is send a positive drug test to the doctor, as well as if there's medical records and an accident report, I'll send it to a doctor. You can usually do those relatively inexpensively, and the doctor will say, okay, the threshold is 50 nanograms per milliliter. This person was at 1,200 nanograms per milliliter. We're going to say they were intoxicated, right? You would think that I could go to a hearing and say that, but I have had hearing officers say, Ms. Brill, did you get your MD since last time I saw you? I didn't. So getting a doctor to say, yes, this person was intoxicated is important, especially when you've got the lower levels. So if they're coming in at 200 or 300 or 400, those are important ones because, again, the person may come in and say, well, yeah, I smoke weed, but I do it, once a week, and I did it on Saturday, and this was on Thursday. So no, I wasn't intoxicated, okay? Again, you never know what they're going to say. We've had people say, my son smokes marijuana in the house, so that must be why I tested positive. Must be. So the burden then shifts to the employee to show that his or intoxication was not the proximate cause of the injury. When we're talking about proximate cause, just because someone tests positive and we think they were intoxicated doesn't necessarily mean that it's going to be denied. If you have someone who's intoxicated, they weren't doing anything wrong though, they were doing their job, and somebody drops a concrete slab on them, it's probably going to be compensable because their intoxication was not the proximate cause of their injury. Their coworker who dropped a concrete slab on them was. Now, someone's intoxicated. Anyone have the yellow lines that people have to walk in? I'm walking over here and I get hit by a forklift. Now I can say the intoxication was a reason, and they were breaking safety rules. So that's where I can use that to show intoxication. But that it doesn't necessarily mean you win. The burden shifts to the employee to show that they were not intoxicated at the time. All right. This slide just sums it all up. Number one, we need a drug policy. Hopefully everyone has their new employees sign their handbooks when they're hired, because otherwise they'll say, well, I didn't even know we had a policy. But if I have a signed acknowledgement that they have received it and read it, you don't have to read it to them. If they sign off on it, I can use that as a hearing to say, I don't care if they said they didn't see it or not. They signed off that they did. They had an opportunity to. Sorry. File the drug test with the Industrial Commission. Make sure it was positive. Make sure it was qualifying. So within 8 hours for alcohol, 32 hours for drugs. And make sure you've got the levels. Then you've got to do the qualifying. So the police officer, someone with reasonable suspicion, the doctor recommended it. And that doesn't mean you went to the emergency room with them and said, I want them to have a drug test while they're here. It's got to be at the request or suggestion of the doctor. And then we've got to file a copy of the signed acknowledgement form with the Industrial Commission. The Industrial Commission only has what we give them, okay? They aren't going to go out and find anything. So if we don't file your handbook policy, your acknowledgement form, the positive drug test that has the levels on it, if we don't file all of that, they don't have it in evidence. Now, you can use your post-accident drug test policy for other things. You can use it for employment-related things. So if you have a policy that says we're going to terminate you if you have if you test positive, whether it's reasonable suspicion, post-accident, that's a totally separate situation. That's an employment issue. For workers' comp purposes, though, you've got to have more. It really depends on the hearing officer, how they feel about drugs, and alcohol in the workplace. It really just depends on the hearing officer how strict they're going to be on these requirements and what you need to have. This says best chance to win. So if I have all of these, then I'm probably in good shape. Okay, so I want to talk about medical marijuana first, and then we're going to talk about the new law, because I think it's important to understand the medical marijuana law, it wasn't superseded by this new law. It's still there. So those provisions still apply. We've now just added the recreational piece to it. So we've got to cut, and I think people don't understand the difference between cannabis, hemp, marijuana. When we're talking about marijuana, there's a definition of it. We're talking about the whole thing, the whole kit and caboodle, okay? Cannabis is the entire plant. Marijuana is when they section it out. Hemp is a little different. Hemp does not have those intoxication properties. And the issues that we're worried about, these are the two that we're worried about. The THC, which is the principal ingredient in cannabis, and it's the one that's got the psychoactive properties. That's what makes people high. The CBD, we hear people talk about that, CBD, all the letters. If you've ever been to a dispensary, I won't ask who's been to one, they'll ask, well, do you want to sleep? Do you want pain relief? Do you want this? Do you want that? And it really depends what the mixture is going to be in the product that you're purchasing. It lacks nearly any psychoactive effects, helps make the psychoactive effects of the THC more tolerable, and reduces the impact of anxiety or paranoia. So like I said, people want to sleep. They'll say, okay, well, you want one that's got more CBD in it. Or if they want to relax a little bit. It all depends on what you want. It's actually kind of a fascinating experience to go in and hear what they have to say. It's very interesting. Hemp is federally legal and the states regulate it. 41 states have legalized production, but not all are equal. So you've probably heard of the Farm Bill, and I'm not going to go into too much detail on that because we're not really here to talk about hemp. I'm not really worried about hemp. You hear a lot of things about hemp socks, hemp clothing, hemp bags, that sort of thing. That's not really my concern. My concern is the marijuana. We know CBD is for sale everywhere, right? I mean, you can get it all over the place. You can get it in the gas station. I mean, you can see CBD all over the place. The big difference between buying CBD in a gas station and buying CBD in a dispensary is the THC. How much THC is in it at all? Optics of the buying experience matter, and the stigma with hemp is near zero. So if you're going and buying a hemp bag or you're just buying hemp, people don't really care. If you're buying marijuana, they care. What do people use medical marijuana for? Pain control, nausea and vomiting, appetite stimulation, muscle spasms, epilepsy and seizures. That's really kind of how it started. Anyone remember the TV show? It was years ago now, talking about medical marijuana or marijuana in general, and people would take their kids who had seizures wherever they could to get the medication that would help with seizures. And usually that was back when Colorado was really the only place you could go. So people would up and move their whole family. Remember that? So there are, and people differ on whether they believe that it does have medical properties or not. Some people say absolutely not. Some people say absolutely yes. But it does have side effects, and we all know this, and this is why we worry about it in our workplace. Dizziness, drowsiness, short-term memory loss, euphoria, anxiety, and psychosis. For some people, it calms them down. For some people, it does the opposite. It makes them paranoid. It makes them scared. You just never know how it's going to impact a particular person. So here we are. Marijuana is a Schedule I drug federally. It's a Schedule II drug in Ohio. The difference, Schedule I drugs, the feds still consider marijuana to be a drug with no currently accepted medical use and a high potential for abuse. In Ohio, we look at it as a drug with a high potential for abuse, with use potentially leading to severe psychological or physical dependence. However, it's not as bad. Federally, it's illegal. State, they say it needs to be regulated. So what does the old law say? The old law is now a few years old at this point. It was limited legalization. It legalizes medical marijuana only for qualifying conditions. These are the qualifying conditions. The biggest one that we see, and the one that they can, if you were to call one of these doctors right now and tell them that you have chronic headaches or chronic neck pain, you don't have to have your family doctor certify that. All you have to do is tell them that, because pain that is either chronic and severe or intractable, you're going to get a card. Okay? They're going to say, okay, that's the one that most people use. People who don't have these other issues. Okay, what forms of medical marijuana can be used? We're talking about THC, Oils, tinctures, plant material, edibles, and patches. A lot of it, right? Can you vape it? Yes. Can you smoke it? No. Now, it's a little different where we are now with the law, but when we're talking about medical marijuana and what you can do. Could you grow it? This is under the old law. No, you could not. We know you can now. Drug driving. It's like DUIs. You can get a DUI for drug driving. Now, look at the level. 10 nanograms per milliliter. What did I tell you it was for an intoxication defense? 50 nanograms per milliliter. A little different. All right, so let's talk about the new law. The new law is called an Act to Regulate and Control Adult Use Cannabis. It was effective December 7th of 2023. It is only available to adults. You've got to be 21 or older, so not 18. It's just like alcohol. It legalizes recreational possession and use. Now, when I say it legalizes recreational possession or use, it's not really, really true. It is still going to be very regulated. Where can I get it? The purchase or sale still remains illegal unless you get it from a licensed and regulated dispensary. Now, I kind of like this because if somebody's going to use, they're going to use. I would much rather have someone buying it from a dispensary. They are highly, highly regulated by the state. Than have them buy it off the street from who knows where. We know that there are huge problems with things being laced with fentanyl and all sorts of things. I would much rather someone buy it from a dispensary than out on the street. You still cannot buy it in another state and bring it back to Ohio because the feds still say it's illegal. So you are committing a crime when you transport it from one state to another. How much can I have? Remember, they used to, they had so much, they were a distributor, or this or that. All right. So you were allowed to have individually 2.5 grams of marijuana, 16 grams of extract, which is oil or hash, and you can grow up to 6 plants in your home, and I believe it's 12 for the household. So you can't have 8 people living in a house and everybody's growing 6 plants each. No. It's 12, and that's going to be, it's going to be quite the operation there. 6 plants, you can grow it on your own. Again, I wouldn't recommend this, but to each his own. The new law is pretty basic. I mean, it's a long law, but there's not really that much to it. Those are the bullet points. A lot of the law is about how are we going to regulate this? What are we going to do with the dispensaries? If you go to a dispensary, I haven't tried this with anyone, but my understanding is that there's a discount. If you have a medical marijuana card, you pay full price if you are just recreational. But you do have to go to that dispensary still. And they are keeping track of who is going. Okay? That's another thing about the dispensaries. They know who is going. You have to fill out a registration. They want your license. So they know who is going. So it is out there. The impact of the new law on your employment issues. So people are like, oh, it's recreationally legal now. I have to let everybody smoke weed. Nope, you don't. The law does not prohibit an employer from refusing to hire, fire, or take adverse employment action against an employee who uses, possesses, or distributes medical marijuana or recreational marijuana. Okay? It actually says this doesn't impact your ability to do this. I know the BWC has a policy. If you look on their website, they have an actual policy that they came out with medical marijuana, and it says we're not going to pay for medical marijuana because they won't allow anything that's federally illegal to be on the reimbursable drugs. The law explicitly states that Ohio employers can maintain complete control over your workplace drug policies, and you don't need to accommodate it. Now that is a little questionable, and it kind of depends on the state. I don't think Ohio is going to say you have to accommodate someone's medical disability. We'll talk about it in a minute. I don't think they're going to say that, just being in Ohio. Some of the other states have said it. I don't think Ohio is going to. So the ADA, everybody knows what the ADA is, protects qualified individuals with disabilities from being discriminated against in connection with employee. You've got to provide reasonable accommodations to someone who comes in and says, hey, I have a disability, I need to be accommodated. When we think of that in general, we think of someone who has a disability where they need to sit for a certain amount of time, or they need a break for a certain amount of time, or they can only, they have restrictions on only using one arm, or they can't lift a certain amount. Those are what we think of as a disability. But one of the issues now is, what if someone comes in and says, my disability requires me to smoke medical marijuana? You don't have to accommodate that. The types of conditions that are excluded, and I think this is why Ohio is not going to say you have to accommodate medical marijuana. People who pose a direct threat to the health or safety of others in the workplace. If your disability that requires you to use medical marijuana, that now makes you a threat to someone in the workplace or yourself, that is excluded from requiring to be reasonably accommodated. The types of reasonable accommodations we think of: making facilities accessible to someone who becomes wheelchair bound, acquiring or modifying equipment, someone needs a special desk or an ergonomic chair, something like that, providing qualified readers or interpreters, modifying workplace policies like leave of absence, job restructuring, modified work schedules, allowing absences to occur outside the standard attendance policy if due to the disability. So how are the states interpreting the right to an accommodation for medical marijuana use? So we know under feds, it's still illegal, right? Many states, when implementing just a medical marijuana statute, provide a carve-out for employers to still enforce their drug-free workplace. So in Ohio, and this is from the law, nothing in the law prohibits an employer from refusing to hire a person because of that person's use, possession, or distribution. So in Ohio, that is our law. New York, however, has done something different, and New York is a little different than Ohio. State law prohibits discrimination based on cannabis use outside of work hours. So their law is not like ours. There are some exceptions if federal law requires drug testing for safety-sensitive roles. And safety-sensitive is different from state to state. But if you have drivers and they've got to be DOT regulated, they've got to be DOT drug tested, you better not let them do it. I wouldn't want them doing it anyways in driving. But you can also classify people in your workplace. So if you have people who do safety-sensitive positions, you can say, you all don't get to use drugs. If you have people who are office workers or something that's not safety, they might sit at their desk and type on a computer. You can say, okay, you people can do it. So you can qualify people, but you've got to treat everyone that's in that class the same. Now, that's not going to fly for your BWC drug-free workplace stuff, but some people will say, hey, I'm not going to be able to get someone to fill this position unless I exempt them from marijuana testing. There are those jobs out there that the type of person you need, it's difficult to find those people. All right. So like I said, in New York, if an employer takes an adverse action against an employee for failing the drug test, but the employee can say that I could still perform my job safely and satisfactorily, the employee can be able to successfully sue the employer for discrimination. I don't think Ohio is going to do that, especially with the way our laws are written and it just being Ohio. I would probably just say we require pre-employment drug testing. If that's what you require. I wouldn't ask them. Yeah, I wouldn't ask them. I would just say this is a requirement. I would think that if they knew they were going to fail it, they probably would say, I'm probably not right for this job. And some people do have a policy that gives a second chance if that's the case. Hey, we're going to drug test you. You know, if you fail it now, we're going to drug test you again in 15 days. In 15 days, if they are not an everyday drug user or, if they don't use it more often, they'll probably be okay. 15, 30 days, whatever you want to make it be. So some people will do that. Then you'll really find out if they're accidentally smoking it before bed, or if they really did smoke it at their cousin's funeral. I wouldn't give them an option to not take it. I always tell people, if it's in your policy, then you need to follow it. Follow it. Don't treat anybody differently, because that's when we get in trouble down the road, is if you've given someone an exception to what your policy says. If you're following your policy, it's going to be a lot easier for me to fight whether it's a workers' comp claim or a discrimination claim or a wrongful termination claim if you follow your policy and everybody's treated the same. But thank you.